My journey in law actually goes back to probably when I was in my second standard, and that's when I took a decision that look, I want to be a lawyer, and that decision was actually based largely on the you know the kind of effort, the kind of hard work, the kind of time that I saw lawyers actually putting in to kind of make a case and be able to fight it out for the benefit of their clients. And that actually I saw at one of my uncle's office. I also saw it as I walked around, and I saw it with other lawyers as well. I basically saw that there was a lot of strength which was there in really becoming a lawyer, and that's when my mind was actually made up. And when my mind was made up, I said, that's what I want to be. And from there till today, I've just stuck to the path, and I said, look, this is something that I've always wanted to do, and I've kind of been there, and I've actually not looked back ever. So that's a very simple story. Started in second standard and continues till today. Today we are, talking about the situation which arises because of IBC, and where we are looking at the IBC and how it has its impact on contract drafting. Now, the subject for today is actually very different from what a regular subject normally would be, because each of us want to always talk about IBC and understand the IBC process and understand how it goes before the NCLAT, understand the resolution plan, and whether when a company goes into liquidation. This is something which is the main features of the IBC. When you're actually looking at the IBC, and I'll give you a 1 minute kind of a summary, although it's not our main topic today. It is a situation where either a creditor, which is a financial creditor or an operational creditor, decides that look, since the money has not come to him, he would like to take this particular company to insolvency, or try and see if there's a way to restructure it through the insolvency mechanism. And he makes a filing basis that because the money has not come, and then the matter goes before the NCLT, and the NCLT then says that look, I'm appointing an interim professional, and I'm declaring a moratorium. And after I declare a moratorium, let's see if someone is coming in and willing to take over this particular company. And if someone is willing to come forward and take over this particular company, I will come up with a resolution plan. And if the lenders are fine with it, let's go ahead. And if not, doesn't work out, let's go for liquidation. So that's a very simple, really, 1 minute kind of a summary of what the IBC is all about. And around this 1 minute summary, you'll actually find there are many, many multiple disputes that arise in this process. There are many issues that come up, etc. But today we are not here to talk about the main aspects of IBC. Today we're here to talk about the ancillary aspects of IBC, and the ancillary aspects. Every law, every statute, whenever it is passed, will always have certain ancillary implications. And IBC is also one such law which has ancillary implications. Today's session is aimed at seeing one aspect or one little aspect of the ancillary implication, which is how does the IBC really impact the drafting of contracts. You see, I mean, we all draft contracts on a regular basis as drafting lawyers, right? I mean, if you're not a drafting lawyer, litigating lawyer, well, you may not draft contracts. But whenever any law is passed, as a draftsman, you would probably need to also examine, when I'm drafting a contract in the future, how does this law affect me? What are the changes this law is bringing? And what are the changes that it's making that I'll have to keep in mind when I'm going ahead and kind of drafting these contracts? That, if you ask me, is is the aspect of this particular seminar today. And we want to focus on seeing how IBC has an impact in terms of drafting contracts. I'll pause here for a minute, because the focus of the seminar, as we said, is not the main IBC itself, right? We are today in a COVID scenario. We are in a situation where post COVID, there could be a number of companies that may end up going into IBC. Today we heard about the cabinet resolution where there's a proposal to give a 6 months kind of a window so that no companies actually end up going to IBC in the 6 months. The level of protectionism, which is very very probably important in times like this. So we may have a situation that nobody can actually no one may be able to take a company to IBC for a 6 months moratorium period, if I may call it that. And if someone is able to kind of take a company to IBC, some each of the contracts that we have kind of drafted will actually come up to play, and we have to understand, right? We have to understand scenarios. So really, that is what we really want to talk about today, and not the main or the key aim of the IBC or what the IBC does. We are today focusing purely on the aspect of how one can go ahead and draft contracts, and is there an impact that the IBC has in terms of how we go about drafting contracts. So with that, I think let's talk through and let's understand certain aspects of uh, certain contracts that we sometimes will draft, and see whether there is an implication that particularly arises from an IBC perspective, right? So first, and the most important contract, which is always considered, is in the nature of a lending contract, right? How and what is the impact of the IBC on a lending contract? Is there a change that you need to make in relation to a lending contract? Let's talk through the journey of a lending contract, specifically when it is likely that a company is going to reach or go into IBC. When a company is likely to, get into some level of trouble, there are always indicators which are there, from various people. There are indicators which are around in terms of, what is going to happen, what is going to be, the play forward, because the management actually starts behaving in a very different fashion. So there are always, what they say, an early warning or early warning signals which you have of a company getting into financial trouble. The first indication of that is, reaching out to try and borrow monies and, increase the leverage to the extent that you can, because leverage is something which is already existing in the market, and you realize that, look, the situation is tough, capital is not coming into the company, you may want to borrow more, right? And when you see companies increasing their leverage, it means that the situation is a bit grim, right? And if now you're coming in as a lender in that scenario, in that grim scenario, and you're lending, you're definitely going to be asking and saying that, look, I'm willing to lend, but the risk is higher. I definitely want to be in a situation where I'm earning an appropriate rate of interest. When I'm lending, I want to be earning a rate, say 20%, 24%, 30%, 36%. Very, very different lenders will have different demands at that point of time, and might want a situation where they're saying, look, I'm not willing to lend because the risk is so high. I don't want to lend unless I get the right rate of interest. So that is one key negotiation that happens when a company is actually in some level of financial debt and it's in trouble and it's likely to go into a level of IBC. Now, when that happens, you will be in a situation where there will be people who will step out and say that, look, I'm there in the market, I'm a lender, I'm a distressed asset lender, I'm willing to come ahead and lend monies at this higher rate of interest. Are you ready to borrow? I'm willing to lend. So there are people who will come forward because they are willing to take sometimes a higher risk than what maybe sometimes maybe a scheduled commercial bank can take, and they're willing to provide the necessary funds. They're willing to provide priority funds. They want to be in a scenario where they want to lend money and say that, look, I'm willing to put the money, but I want my money to be repaid first over other lenders, right? So there are different situations of this which arise, and therefore contracts will need to be drafted for that particular scenario, right? When we are drafting such contracts, questions arise, what are the safeguards that the IBC legislation itself is throwing in our face that we need to see, so that when we are drafting the contracts, we don't end up just drafting it blindly, and we end up at least giving our clients the right advice in relation to the matter, which they've kind of brought before us. Now, to give the right advice, we have to know the provisions of the IBC, and we need to know the provisions well enough to be able to kind of guide our clients. Now, when you're drafting a contract, questions will also arise in terms of how do I word my event of default clauses? What are the kind of, what is the language that I need to use so that, I am protected in a scenario if this company was to go into IBC? What do I do about my security documentation, right? What do I do in relation to drafting my documentation in a manner that it is at least, IBC beneficial and not neutral or negative, in terms of the IBC regulations. So all these thoughts, really would come to your mind, and you want to be in a position where you are able to draft a contract in a manner that, it is, let me say, IBC proof, or it is at least IBC resistant, and you're able to succeed in relation to these kind of matters. So now, basis that, let's take up, some of the provisions of the IBC, which we may have to possibly keep in mind if we have to draft, these kind of contracts. What I will do is also, basically share probably the IBC with everybody so that we can, talk about what the IBC says. So there we are. This is the code by itself, the IBC code. And this is the one which is, amended up till date. Some of the things which are relevant from the perspective of the IBC code, which we have to use to kind of guide us to draft contracts, will include, for example, the definition of financial debt. Now, why is the definition of financial debt important to us? The definition of financial debt is important to us because when we are dealing with a situation of a financial debt, a financial debtor gets a different treatment in IBC when compared to an operational creditor, because a financial creditor who basically has lent a financial debt gets the right to sit in what you would call the committee of creditors and is able to therefore vote on matters which have to be decided in relation to the IBC. So it is important that, when we are drafting your lending contract, you have to keep in mind that the loan or the loan that is being provided or the security which is getting created meets the definition of financial debt, so that tomorrow you are not in a position to, you're not in a scenario where somebody comes back and says that, look, you're not allowed to sit on the committee of creditors. Your company has now gone into IBC, and so be it. You can't take the benefit. The definition of financial debt, which has in fact recently been interpreted by the Supreme Court also in the JP Infra judgment, that has actually gone ahead and focused on what is this time value of money. So financial debt means a debt along with interest, which is dispersed and so and so for the consideration for the time value of money. Now, what is the consideration for time value of money? The court has spent a lot of time trying to decide that. They are saying ultimately that, sometimes if you are a third party security provider, you may not be considered to be a financial debtor, because if you are in a situation where you haven't borrowed the money yourself, but you've only created the security, and the security has been created in favor of a third party for a loan which has been taken, let's say, by a sister company, then in such an event, your security doesn't show any time value of money within the system of the company, and therefore you will not be in the nature of, may not be in the nature of a financial debt. So if that is not the case, you may actually be out of the IBC in terms of, being a financial debtor, and you may not be allowed to be sitting in the committee of creditors. So if these kind of principles are in your mind, you will be in a position to possibly draft your contract in such a way, keeping this at the back of your mind and being able to say that, okay, when I'm drafting a loan agreement, if this debt comes in the nature of, a third party security which is being provided, for it to be a financial debt, at least what I must try and do is to try and bring it under, the subclause I, which you see right now in front of you, where it deals with the amount of liability in respect of any guarantee or indemnity in relation to the matters which are set out here. So that, I think, is one of the points which we need to kind of, keep at the back of the mind while we are drafting. What I will do is, before I proceed further on some of the other provisions, I think a lot of, queries have been raised till now. And I will spend a minute just answering and clarifying some of the doubts which have been raised, and we'll proceed further. One of the questions which I think has arisen is, what is the meaning of leverage, and what is the
mechanism, and how does one really go about dealing with?
So leverage as a concept is really, when you're dealing with your debt in your company, when you compare your capital and debt together, you decide how levered you are. Basically, if you have borrowed more money than the investment in the company, that is what you would really call leverage, because you have borrowed to grow your business, and that's what leverage is all about. And basically, what is so basically, when you are actually going through the mechanism of understanding this as what is leverage, you will find that leverage is something which is just the borrowing and how heavy the borrowing is. When you say someone is over leveraged, you basically mean that the borrowing is actually at a very, very high level, and that's when actually you really start going into trouble, because you're not able to kind of generate sufficient revenue to service and repay the borrow. That is when you're actually starting to go towards your path towards an IBC. So that's the background to it. That's the background to really to say what a leverage concept is. So now going further, we are dealing with also we also spoke about an event of default clause and how we need to keep that at the back of our mind. And I've also seen a query specifically relating to an event of default, and basically where how to word your event of default clause in a loan agreement always becomes a very, very important question, because the importance of that really comes from the moratorium perspective. So let's first go down the provisions and look at section 14 of the act. So what happens under the provisions of 14 is that once a moratorium has been passed, right? Once the insolvency commencement has basically happened, and once the insolvency commencement date has come in, the adjudicating officer is obliged to basically go ahead and declare a moratorium which prohibits each of these matters. So this is actually one of the key aspects of the IBC, is that whenever an IBC proceeding starts, whenever any queries are specifically asked, then there is a scenario where the IBC actually deals with a situation where a moratorium order gets passed. And if a moratorium order gets passed, then nobody can go ahead and enforce the security. No one can go ahead and bring about new suits or proceedings, and no one can really go ahead and do these kind of different things which are kind of prohibited here, right? You cannot foreclose an asset, you cannot recover a security interest, you cannot recover a property if you're an owner or a lessor. So when that is the scenario you are put into, it becomes very important to how should I word my EOD clause. Historically, EOD clauses are also supported at times because of the heavy negotiation that happens on the drafting of the EOD clause with by cure periods. So at times, if there is a payment default, there is a cure period which is always provided, saying that, okay, you have a 15-day cure period for certain things, you have a 30-day cure period for certain things. Now, the danger of, providing some of these cure periods is that, look, when we are in a scenario where the IBC comes to strike and a moratorium actually ends up getting passed, then you are actually stalled and you're stopped completely from being in a position to enforce your security. Your entire security, in fact, goes for a toss. So, therefore, the question will come up in terms of when you're drafting an event of default clause in any loan agreement. Should you not take into consideration the fact that there is a moratorium period, and that moratorium may actually come into play very soon, and therefore you may actually need to be in a position to enforce your security earlier rather than later. So if I have to go ahead and invoke my security earlier rather than later, don't I need to draft my event of default clause in such a way that I don't have sufficient cure period being provided to the borrower, so that you are in a position as a lender to be able to take quick action if the need arises? Of course, it also depends on the nature of the security you have, because even sometimes if you actually say that, look, there's no kind of a cure period, I don't, within 2 days, if you don't pay, I have the right to enforce my security. You may be able to enforce the security in case of a pledge. You may be able to enforce the security in case of any other movable property which has actually been pledged in your favor. But if it comes to a scenario where your asset is in the nature of a mortgage, or it's in the nature of it's the nature of a hypothecation over certain fixed assets, then in such an event, for you to be able to go ahead and enforce that, even during the moratorium, before the moratorium comes, may actually become close to impossible. So you have to therefore keep that also at the back of your mind, that in certain cases, depending on the nature of the security, the enforcement period and the cure period may actually sometimes become irrelevant, because you want to be able to enforce it as soon as possible to prevent the moratorium from coming to attack you. So, that is, I think, of course, addressing the, point about the, query specifically, which also rose on the, in relation to the event of default. Uh, Now, if you end up giving 15 or 30 days as a kind of an event or default rectification period, then you actually are going to get into trouble. So that is definitely the kind of scenario that one may go into. Now we have to see, basically, if basically we have to therefore go to the mechanism, specifically insofar as understanding how we will need to kind of draft some of our contracts and keep in mind the provisions of section 14. Now I took the example of a lending contract, but in the lending contract I also spoke about a situation where I'm actually willing to come in as a lender, and I'm willing to give a loan provided you pay me a higher rate of interest. I want a 30% interest or a 26% interest or a 24% interest, because I know these are difficult times, right? Now, while the borrower is in a desperate scenario, he is in a situation where he says, please give me money, whatever rate you ask, I'm willing to give, because I need money to service my loans currently, etc., etc. There is always an inherent default, an inherent risk of whether that lending which has been particularly given at that high rate, whether it will be considered by any reason as an extortionate credit transaction. Now, the Insolvency Act, the IBC also deals with a situation of, what is an extortionate credit transaction. And if if a transaction is considered to be an extortionate credit transaction, then your resolution professional has a right to come back and say that I want to set aside this transaction and I don't think this is a proper transaction for the borrower to happen. So taking advantages of a situation, may actually really not be the best way to deal with what you are kind of want to do. And the minute you kind of go through a mechanism where you go ahead and lend at a rate which can be a scary rate, the danger of that is that it opens up this belt of what is an extortionate credit reaction. What I will do is I will also show you the width of the rules, and how they go about expanding the definition of extortionate credit transaction. It will just give me a minute. I'll have to stop share and start share of the other file. So these are the rules before us. Here's rule 5. A transaction shall be considered to be an extortionate credit transaction under section 52, where the terms require the corporate debtor to make exorbitant payments in respect of the credit provided, or are unconscionable under the principles of law relating to contracts. Now, I definitely, couldn't have asked for a worse drafting, because this leaves it so open in terms of, what is unconscionable. What is unconscionable under principles of the law of contract is something which, any forum can come to a different view on. What do you mean by it's considered exorbitant in respect of the credit provided? Is 24% exorbitant? Is 30% exorbitant? I mean, the word exorbitant again is an undefined term. So I couldn't have really asked for a worse drafting. But this is the law, and this is the regulation which is there before us. If the regulation at the end of the day states this, then I have to be cautious when I'm going to go ahead and create new loan facilities which are being given when there is a likelihood of an insolvency event coming in for the borrower. Because then this is not saying that, look, I have to go through the mechanics of understanding, what is it extortionate under any other particular law. It's only saying that it's considered extortionate when it has some exorbitant payment. Exorbitant is anybody's guess. Anyone can come back and say, no, 24% is exorbitant. I mean, I'm sorry, you can't charge that kind of return. If you were to charge 24%, no, it's not done. In today's market, getting, banks don't give you more than 4 to 6% interest. So, I mean, any right lending rate should be in region of 12, 13, 14, 15. Anything beyond that is exorbitant. So someone can always come back and, build that argument. And if the resolution professional actually does that, this transaction can actually be set aside by the adjudicating authority. And in which case, if it's been kind of set aside and you're no longer a creditor, maybe a security goes, you may have to stand in the queue and, get something only finally as an operational creditor. So therefore, when you're drafting this, it is our duty to kind of bring to the attention of our clients the situation that, look, you can't be exorbitant in any form. And therefore, your lending rate has to be, monitored, and it has to be generally, fit within what is considered conscionable, right? Because when you're dealing with unconscionable, you actually have to deal with conscionable. And you have to have a clean and good conscience to believe that what you're charging is not exorbitant. So again, that also therefore has a very strong impact, and it will have a position. Um, it will have a position in terms of it will have an impact of impacting your contract which you have gone through. So if you don't draft your contract right and you don't draft the right rate of interest, you are actually putting your own client into trouble. Um, I'm actually seeing a lot of questions which are coming up on different topics like comparing SARFAESI versus IBC and things of that sort. But that is not really our theme for today. We can always have a follow-up session on different other themes which may arise. But today's theme is really focused on what is the impact of IBC in terms of drafting contracts. So we will limit the theme to what today's theme is, and therefore, if questions are linked to today's theme, my request is to go ahead and make it, and not go into ancillary topics, because that is something which we won't take up today because we may not even have the time to do that. So let's go ahead and talk about. We spoke about lending contracts. Let's speak about let's say a lease. Now, again under the moratorium, there is a clear provision, which says that the lease or the owner or a lessor cannot recover back his property in the moratorium period. Now, um, the what is the what does that mean? So, if I'm a landlord and I'm going to be drafting a lease deed or a license agreement, because leave-in license is commonly what we sometimes use in Maharashtra, I'm giving somebody a license to get into the premises and use the premises. But definitely when someone is going into IBC, I need to understand what is the impact of the IBC on my license or lease, because my property under the moratorium actually gets stuck. So let's go through let's examine the aspect relating to um, let's examine the aspect relating to section 14 again, particularly looking at from a lease basis. I'm just stopping the share of this document, and I'll take you back to the lease, to the main IBC itself, and we will look at section 14 again. So now when we're looking at section 14, if you look at the recovery of any property by a owner or lessor, where such property is occupied by or in the possession of a corporate debtor. So if you look at this, it's clearly a moratorium on you being able to even take back the recovery of your property during this, so long as the moratorium continues. Now, if you are in a position where this property cannot be taken back, if you have to start thinking now as a drafting lawyer, you have to ask yourself the question that when I'm going ahead and drafting a lease document, what do I need to do to protect my client who is perhaps the lessor? Right? Can I build some clauses? So one question which will normally come up is that, look, okay, I don't want to draft it as a lease because the section uses the word lessor. Maybe let me draft it as a leave-in license, and then I can try and build an argument that it will not fit within the moratorium. But is that correct? Now, if you look at the width and the amplitude of the language, it actually says it is prohibiting the recovery of any property by an owner, and it says or lessor. So it goes the width of saying that, look, when you are an owner of a property, you cannot recover your property. Whether therefore the document is in the nature of a leave-in license, whether the document is in the nature of a lease, there is nothing that can actually save you from this particular moratorium. So then comes the question that, look, if I can't be saved, but can't I say that, look, there's no interest which has been created in the property, because a lease requires the creation of an interest in the property. And if the lease requires the creation of an interest in the property, then you have to be in a position to say that, okay, I'm not the lease has not been at I'm not creating an interest. It's a leave and license document, and a leave of license document and not created interest. Can't I at least take back possession? Also, we have a clause in the leave and license document saying that possession is never given or never agreed to be given. Also, it's only the right to use which has been given. Now, again comes the language here, right? So again, that is like playing with language, if you were to ask me, because here the width of the document is that you can't recover any property by an owner or lessor where such property is occupied by or in the possession of the corporate debtor. So this section goes wider. It says that even if it is in your occupation or it is in the possession. Now, arguments can always be taken that on a leave license, it is not in his possession. I don't even give him a right to enter upon and use. But is it not occupied by him? Is it not in a situation where someone will come back and say, no, possession is also to that extent? Maybe there it's a right to use, but therefore for the use, he is occupying the premises. So I'm not saying the answer to that is black and white. In fact, the answer to that is gray. And yes, I mean, doing drafting it in the form of a lease license at least gives you that additional argument to take that the moratorium cannot affect my, situation of being able to recover my premises because my license fee has not been paid. And he was never in possession because that is something which is already written in black and white into the document, and therefore have the right to go ahead and recover if the document is in the nature of a leave-in license. So I can always go through that, mechanics, and I can always build that particular argument. But is it black and white? Perhaps not. Perhaps not. Then comes the question that, okay, if my landlord has to anyway take the hit because there's really no other option to him, what do I do? How do I make sure I'm in a position to at least protect him? And, he gets, because if he has to wait till the secured creditors, unsecured creditors come in the operational creditor queue and then take his money, then there is definitely a situation which, can be very scary. Now there, I think there is, a level of safeguard which you can always use to kind of, guide your specific clients when you go down the path of.
That particular safeguard is actually once again found in the priority of payments. And if you were to look at the priority of payments which exist and the priority of payments which
you will actually find that priority of payments will allow priority for the insolvency costs, and certain other administrative costs will always come first before the payments go to any of the secured creditors. So there is a priority of that nature which is always there. And here I just want to once again share with you the rules. Insolvency resolution process cost. The insolvency resolution process cost under section 513E shall mean amounts due to suppliers of essential goods and services under regulation 32, fee payable to an authorized representative under so and so, out of pocket expenses for discharge of function in 25, amounts paid due to a person whose rights are prejudicially affected on account of the moratorium imposed under 14.1D. Now, if you're coming under the provisions of 14.1D and your position is being prejudiced, then under these rules, you are being treated ultimately in priority, and you're getting a mechanism where this is going to be treated as a resolution process cost. If it is treated as a resolution process cost, then you are opening up your Pandora's box for saying that this money needs to come to me in priority, even though it's in the nature of a lease. And that is something which you will be able to therefore use to your advantage But again, to use it to your advantage, you have to be able to also, I mean, one argument is that, look, the law anyway provides this, you don't need to draft it or properly in your contract. But again, go by the language, because if you see the language which is there, amounts due to a person whose rights are prejudiciously affected on account of the moratorium imposed under Section 14(1)(d). So when it says your rights are prejudiciously affected, so should you not be providing something in your drafting of your contract saying that if there is a scenario where any of your payments are withheld, or your client goes into, you know, the lessee or the licensee goes into IBC, that you are going to be specifically deemed to be prejudicially affected because you're actually losing your benefits and all your rights in that regard. Again, there's an argument that, you know, you don't need to necessarily draft it, it's automatic. But it's important as a drafting lawyer to kind of, you know, keep that in mind whenever you're kind of looking at a lease document as well. I'll just pause and just see if there's any some specific questions which need to be specifically looked at this point of time. So one question, I think, is back to the extortionate rate of interest, where one of the questions has been asked is that, can I not just put into the document or the agreement a particular clause saying that under current environment, the rate of interest is not deemed to be extortionate? But the testing really is not being done on the basis of the agreement, right? The testing is going to be done by your resolution professional. Under the, again, back into the rules, the resolution professional is given a particular period of time where he has to bring to the committee of creditors what transactions he considers to be extortionate and which ones he considers that, you know, need to be kind of impacted and changed. And it's his choice really to decide which one is extortionate and which one is not. It is his Pandora's box which he has to play with. He has to believe that it is, you know, unconscionable, conscionable, and, you know, things of that sort are, you know, what we can, you know, deal with. Those are the situations which he will have to deal with. And therefore, there is no real, let me say, scenario where you can actually, just by putting it into agreement, be able to guarantee that it will be not treated as extortionate. But yes, by dealing with the scenario where you build the story through, you know, various emails, communications, where the borrower says that I am not able to get interest, you know, I'm not able to get loans right now in the market. I am in a desperate need. No one is willing to lend. You actually turn out to be the only lender who is willing to lend. All the circumstances may be used to show it is not extortionate and it's a situation-based loan, right? And that is something which, you know, we'll have to therefore tackle as we kind of go along. And you have to keep in mind that, look, maybe it's probably better to build some level of correspondence if you are to be able to demonstrate that it is not extortionate. One question is, of course, come that, look, can I not just put a clause into the agreement that there cannot be an invocation of a resolution process under the IBC at all? So, or, you know, that is that some kind of a protection that we can always draft in our agreements. Now, the right to move the IBC ultimately is not only with the borrower, because your borrower is not the only person who can go to IBC. Any lender can go. Any operational creditor can go, provided now, of course, with the amendment, you know, he has an amount due to him of more than 1 crore. Anyone can go to IBC and say, look, this money has not been paid to me. And therefore, you put the company into IBC and take it through the resolution plan process. So there's not much of a say that we can have in terms of a contract to actually go through a mechanism of necessarily drafting something which, you know, by a particular clause or coming to a protection by saying that, no, you can't go to IBC and that's the end of it. Yes, I mean, will that clause also at least prohibit the borrower from going to IBC? I mean, you can always put in a clause that without my prior consent, that, you know, please do not make any reference to IBC. So voluntary filing to IBC, you may definitely be able to build some kind of a contractual arrangement to seek your prior written consent before anyone was to go to IBC. But you can't stop a third party from going. So the contract is never going to be binding on any third party. And so therefore building that clause by itself will not, you know, clause will not, you know, bring about the kind of solution that we are looking at. So basically, I think the other kind of contracts which also, you know, will come into play is, contracts relating to property, for example. Whenever a company is actually in trouble, you will find that the first thing they want to do is kind of liquidate their immovable properties. And they'll want to kind of see if there's a way to kind of sell some surplus liquidate, some property of theirs, use that to kind of raise money and meet the scenarios. Because actually, when people are in good times, they usually use surplus money and, buy some immovable properties and keep it with the hope that whenever there's expansion, you can use it. So one aspect that a company always considers whenever it's going to be, facing the fear of an IBC going forward is, should we go ahead and, liquidate some immovable property and sell them? Now, in that scenario, if you're actually, going ahead and, liquidating some level of immovable properties, again, this is a situation which will often be considered to be like a desperate sale. You are in a position which, the sale has been kind of, treated as a distress sale. And therefore, you may not really be able to get the right value because you're selling in a hurry. And if you're selling in a hurry, you will get whatever value that a good sharp player is willing to pay you in that particular market and that particular time. Now, if that does happen, again, when you're acting for the buyer, sometimes the buyer will always believe that, look, this is the best thing that can ever happen to me because, I'm getting a property for cheap. I'm getting it at what I would consider as a discount to value. I'm able to use my surplus funds currently to go ahead and, buy this. But again, it is important for us to then guide our clients to say that, look, that's not good enough because once again, the resolution professional has powers to treat these kind of contracts also as undervalued transactions. So there's a clear provision in the IBC which also deals with transactions being treated as undervalued transactions. And if it is treated as an undervalued transaction, the impact of them being an undervalued transaction again is that the resolution professional has the required right to say that, look, all these should be kind of set aside and request the committee of creditors to even take it before the adjudication authority and suggest that these kind of transactions be set aside. So this is an additional impact which is there. So even when you're buying properties in distress, you must always kind of bring in the right value or valuation in place to make sure that even in a distress scenario, you're not buying the property at a price which is below the valuation price. And if it's being bought at a price below the valuation price, expect that if the property is going to go into and the company is going to go into an IBC, there will be a scenario where this sale will be kind of set aside. And there's a risk that you're taking in that regard to kind of, not probably get your money back because you may then just stand in queue like any other creditor and not really get your money. So sometimes for, 1 rupee profit, you may actually lose your entire property. And that is where you have to be very cautious in terms of, guiding your clients specifically down this path. Shareholder agreements. I think I saw a question earlier also about events of defaults under shareholder agreement. Very often, in fact, we see shareholder agreements having event of default clauses. And these event of default clauses under shareholder agreements actually say that if a company or my joint venture partner actually was to go into a default or an EOD, then in such an event, I can buy him out at 90% of the fair market value. Now, if you are saying that, look, I can buy him out at 90% of the fair market value, why will the resolution professional allow that to happen as a matter of right? Why will he not come back and say your contract is actually an onerous contract and therefore to that extent not appropriate? Because you're trying to buy out a property which is not at its fair market value, but it's at an undervalue. So once again, you see, when you're drafting a shareholder agreement and defining an event of default clause, and which gives you a right to purchase somebody's shares if someone goes through insolvency or bankruptcy at a price which is lesser than the fair market value, that means at the end of the day, the clause will not work in an IBC scenario at all. And if your client really wants to buy it, you'll probably be advising your client and telling them that, look, don't do it at a price which is below the fair market value. Do it at a price which is equal to and appropriately based on the fair market value. So I think this is just a kind of a flavor of some of the contracts. I also wanted to spend a minute or two on some of the contracts relating to essential some commodities and non-essential commodities. So I'll just spend a minute or two there. Even there's a clear provision again in 14 that even when it comes to kind of essential commodities, which are any standard supply contracts relating to water, electricity, and telecommunication and IP services. So these kind of contracts, which are in the nature of IT services and technology, they are not something which you can actually suspend during the moratorium, and you have to kind of continue doing that. But we saw earlier when we were flipping through the rules that even when it comes to the payouts that need to be made in relation to these contracts, they will also get the same priority. So when you're drafting such contracts and it relates to the essential commodities which is being provided in this form, you know that look, when the money is at a priority, whatever is realized, even it may be probably higher than the secured creditor as well, you will still be able to, you'll still have to kind of get that money even before the secured creditor gets it. So you are in a kind of a superior position, and you probably don't need to worry. So you have to be able to position to kind of advise that to your clients and categorize and decide to categorize whether his service is in the nature of an essential service or not. Now, why I spoke about essential and non-essential? Because if it is not in the nature of an essential service and the service is in the nature of, let's say, a critical service, which is important, the same benefit doesn't flow insofar as the pricing is concerned here. So in terms of a critical service, the only statement which is made under 14 is that look, the RP can decide which service is a critical service and which goods are critical goods to be kind of supplied for the company to have its own continuity. And you cannot stop the supply of those goods then unless you are not getting payments for the period post the commencement of this insolvency. So past you may have to hold on, but whatever you're being forced by the RP to kind of take forward and provide, for that the payment should come on a regular basis, and if that's coming on a regular basis, you cannot stop. So again, to be able to negotiate those clauses and draft those clauses in the contract, we will need to kind of keep in mind that we will need some level of skill sets to reach that. So I think broadly, this is what I wanted to kind of bring to your attention in terms of contracts. Take on some Q&As.
Can you provide few examples of major EOD clause to make agreement IBC proof?
We did, to make it IBC protection based and allow, if you are going through a mechanism of, drafting an agreement from an event of default perspective, obviously the first thing you want to do is make sure that you are not losing your priority and potential of enforcement. So therefore, the urgency of being able to enforce your EOD is probably the most paramount. So lesser cure periods, lesser time being provided to third party, for whatever needs to be done. Whenever an IBC protection clause is really needed, you have to make sure that you're drafting it in a manner that the event of default gets kind of invoked, even if there is a situation where someone is immediately referring a matter to IBC, and in that kind of a situation as well, you will be able to have the right to go ahead and enforce your security. Of course, this relates to your security, which may be in the nature of which may be in the nature of some of the other which may be in the nature of your movable assets. But when it comes to an immovable property, you may not be in a position really to go ahead and enforce the security in the same manner. And therefore, even if you put some of these clauses, you may not be really be able to come to a situation where it actually becomes IBC proof. Your immovable property is protected through your IBC process in any event, and you have to kind of run through the process and be able to take that forward. But the speed really becomes of the essence when it comes to an EOD clause.
Ashish, would you like to take the other questions? Shall I
Yes,
read them?
Yeah, why not? Please.
Sure. If a company defaults in making payment to its employees, will this be called a financial debt? Is there any specific limit of debt amount? Will one person company or proprietary firm will also be covered under this?
So I think for today's session, the important part probably is relating to um, but the employee payments, and the employee payments are your regular operational debt, and it doesn't become really in the nature of a financial debt. And your employees can also, of course, go to the IBC for this. But again, the amounts due must be in excess of 1 crore now after the changes. And even in this COVID scenario times, while the Ministry of Home Affairs has kind of mandated that these kind of payments would need to be made, there are petitions pending before the High Court and the Supreme Court where this is actually being considered. And there are challenges being made because there are companies who are standing up and saying, look, I don't have the money to pay, and if I go up paying, I mean, there is no question I'm actually going to go an IBC situation. So there is no other alternative which is left for me but to go to an IBC scenario in case I'm not in a position to pay. So some of these things are actually happening as we go along, and we have to wait and see what the outcome of the court proceedings is going to be, and decisions can be taken on that basis.
The next question is, does Section 14 of Moratorium apply even in case of default under 138 NI Act?
So 138 is a criminal procedure, right? So what happens is that the moratorium stops you from enforcing and recovering things from the company. Largely, I think, when it comes to 138 proceedings, they are pure criminal proceedings. So it's not that the moratorium, may impact them to go and proceed with the criminal processes which are there. It's only enforcement of security, being able to take something away from the borrower. So even if you finally ultimately even get an order in the criminal proceeding where there's a penalty, in any case, all you can really do is go ahead and make a claim before the IBC and say that, look, this is the money which is due to me. So why don't you please now put me in the queue and I'll take the money as we go along.
If an insolvency professional becomes a whole-time director of an insolvency professional entity, then what will be the status of his COP if he, as a professional, such as a CA, CS, etc.?
Again, not relevant for today's discussion. So I think it's not linked to drafting of contracts and IBC, so we can take that up another time. So that requires a complete discourse by itself in terms of the way we go about that.
What will be the status of notices sent to company for recovery of suppliers' payment while COVID moratorium is being in place?
So your notice is not, I mean, if a COVID moratorium is in place and you are actually in a scenario where you are not being paid by your particular, your supply goes to X and X has not paid you with money yet, I mean, he's bound to pay you. There's no two ways about it. But if there's a force majeure clause in your own, contract, then he may come back and say that because of a force majeure event, I'm not able to pay you as of now. But again, that's again a discussion for another day, and it's not really, I think, the scope for today's class.
It is settled that if there is a pre-existing dispute, an OC cannot initiate CIRP. But if an FC initiates CIRP, then can that OC make a claim before IRP for his operation debt? If not, what is his remedy?
So what may happen in the sense that if you are in that, the situation where you are an operational creditor and there is a dispute relating to it, that dispute at the end of the day has to be really decided this way or that way for you to get the benefit of your claim. Now, even if you were to go ahead and make a claim, because if the financial creditor comes ahead and starts the insolvency process, there is a claim form which you have to fill up and file. It is up to the IRP to admit your claim or not admit your claim. And if he refuses to admit your claim and says this is not a claim which I'm willing to accept, then you have to battle it out. You have to go through the mechanism of finding a solution where you say that I am entitled to this money, and therefore I'm entitled to go ahead and claim this particular money. And only you have to establish it. Only the IRP and the final RP really goes ahead and accepts that, then only you're in a position to make that claim. So you'd have to go and justify it and be able to say that I'm entitled to this money, and what the company is saying in terms of a dispute is no good, right? It's not really which is going to help. But again, as I said, not a topic for today. That's another long-term debate in terms of how to fight those matters.